Hello and welcome to a session on the Utah Land Use Institute workshop series related to impact fees. My name is Craig Call. I'm the executive director of the Utah Land Use Institute, and we appreciate very much your being involved in this conversation today. Before we begin, let me thank the Utah Department of Workforce Services, particularly the Division of Housing and Community Development. They have provided the funding for this series of workshops, and we appreciate their support. We also appreciate the Office of the Property Rights Ombudsman and the Department of Commerce. They are funding the Utah Land Use Library, found at utahlanduse.org, where what you're about to participate in is part of the permanent collection there, provided for the informative purposes for those that are involved in the land use arena. We also thank the S.J. and Jesse E. Quinney Foundation, our longtime supporters of the Utah Land Use Institute. There are significant materials online. This, for example, the speaker here, Chase Andrisi, has done a terrific job of compiling materials and preparing them in a way that you can use. They are available online. It's that same website, utahlanduse.org, at the tab Workshops. And there you'll see this. It'll also be provided in the Land Use Library. Again, if you have comments or questions at any time, please address them to info@utahlanduse.org. That said, let me turn the time over to Chase Andrisi, who is our gifted scholar on the subject of impact fees. Chase?
Thank you, Craig. I wouldn't agree with that statement, but it is something I'm passionate about, and grateful for the opportunity to talk about this for a brief moment. There's obviously more to impact fees than you could address in the time that we have here today, but I'll do my best to try to lay some foundation and some groundwork, and hopefully we can learn a thing or two together about impact fees. Briefly, just about me, I think some context is helpful. In my private practice, spent a number of years representing cities, fought developers on impact fees, helped cities pass and adopt impact fees. Then I left that realm, and I now work for a developer where I'm sitting on the other side of the table oftentimes. But really, I say that in jest a little bit. Oftentimes, it's helpful to have an understanding of impact fees when you're representing developers and representing cities, or working with cities to help implement impact fees. And I found that in both of those practices and both sides of the table, it's been helpful to have a basic understanding of how this all works. Let me share my screen. I've presented a few slides here that we can follow along with. All right. Let me know if that's not working, but I've been doing this virtual work long enough that hopefully I've got it figured out for everybody. So again, I'll be covering briefly just a little bit about exactions and the rough proportionality analysis of Nolan and Dolan. For those who are watching this who haven't been participating in the larger presentation, the Utah Land Use Institute has another video and other additional materials on the principles of exactions, and I would encourage you to go look at those and how they relate more broadly to land use. For my purposes today, I'll simply just be talking about some of the general principles of exactions and how they set the stage for impact fees in the state of Utah. Also, just want to talk briefly about how local governments can collect, use, enact impact fees, some of the other regulations tied to that, and then talk briefly just about the impact fees, the Utah Impact Fee Act. Again, I want to just dive in briefly on exactions. I don't think you can sufficiently talk about impact fees without talking about the principle of an exaction, because an impact fee is by definition an exaction. An exaction is just a contribution of land that's required of a local government in connection with development approval. It's a condition that must be satisfied in order for that approval to be effective. In Utah, we often see exactions in the form of dedications of land, construction, building of public improvements in lieu of paying for those public improvements. And in the case of impact fees, money can be exacted from development as a condition of land use approval. The idea behind exactions is that they're designed to mitigate the impacts of new development on existing and future public facilities that are provided by a municipality or a local government. The scope or the analysis that we use when we're talking about whether or not an exaction is appropriate is the rough proportionality analysis. This was really established in two landmark Supreme Court cases. I'll talk briefly about them. Again, if you want to dive into that a little more detail, there's some additional materials available through the Land Use Institute for that. But those two cases are Nolan versus the California Coastal Commission and Dolan v. City of Tigard. The Nolan case, just briefly, deals with a property owner who had some beachfront property in California. They made a land use application to the California Coastal Commission. That commission had certain land use authority over that application. They approved it, but they required of the Nolans that they dedicate a portion of their property as a public access easement. The commission had this stated policy that they were to encourage public access to beaches. And so in furtherance of that policy, they required the Nolans, as part of their land use approval, to dedicate a strip of their land so that this policy could be carried out. Nolans obviously didn't agree with that, found it to be illegal in their mind, and so they challenged that up through the state courts, and ultimately it made its way to the United States Supreme Court. The Nolan's argument obviously was pretty simple, that this condition was a taking without just compensation. And the commission, however, argued that this was simply a legislative approval process that they could go through, and that they could either choose to approve that with conditions or deny it if they found that that denial would have mitigated the impacts or otherwise furthered the policy that they were trying to promote. It's a little bit of mental gymnastics on the part of the commission, not a terrible argument on their part, I would say, but as we'll see here in just a minute, the United States Supreme Court didn't see it the same way. In fact, the Supreme Court found that there had to be a connection between the condition that was being imposed by the commission and the governmental interest that they were trying to promote. The United States Supreme Court found that the public access policy that the commission was trying to promote was in fact a legitimate interest, but that the requirement that the Nolans dedicate a portion of their property was not sufficiently tied to that policy. And the key word or the takeaway from the Nolan case is that there has to be an essential nexus, an essential connection between that condition that's being imposed and the governmental interest at issue. I pulled this quote out of that decision from the court. I think it's pretty interesting and pretty telling. I'll just read it briefly, but when the essential nexus is eliminated, the situation becomes the same as if California law forbade shouting fire in a crowded theater, but granted dispensations to those willing to contribute $100 to the state treasury. While a ban on shouting fire can be the core exercise of the state's police power to protect the public safety and can thus meet even our stringent standards for the regulation of speech, adding the unrelated condition alters the purpose to one which, while it may be legitimate, is inadequate to sustain the ban. Therefore, even though in a sense requiring a $100 tax contribution in order to shout fire is a lesser restriction of speech than an outright ban, it would not pass constitutional muster. Again, just clarifying that there has to be not just a connection, but an essential connection between the governmental interest and the condition that's being applied to the land use approval, the exaction. One of the other cases, again, Dolan v. City of Tigard. This one involves a landowner who applied to the city her planning commission review required, or the planning commission in approving her land use application required her to dedicate a portion of her property to improve a storm drain facility, and also to dedicate some of her property for use as a trail or a pathway. The planning commission loosely based those conditions on kind of their thought that there was going to be some impact to the storm drain facilities. They didn't articulate or quantify what that was. Same thing held for the trail dedication requirement. They looked at that and said, this additional building space is likely to require or drive additional traffic to the area. And as a result, we need you to dedicate this 15-foot strip. I think it's important to note as well that that amount of property that they were requiring her to dedicate was approximately 10% of her total site, which, as we talk about the mathematical requirement or a quantification of what that exaction looks like, I think is relevant, not only to this case, but as we talk about impact fees here in just a minute as well. Dolan argued essentially that the planning commission's requirements, those conditions that they required of her approval, were not consistent with the Supreme Court's essential nexus requirement in Nolan. The planning commission, again, simply argued that no, there's going to be impacts from this development. We're trying to mitigate those by requiring her to dedicate some storm drain facilities, as well as include a 15-foot path for additional traffic in the area. The court, I think it's important to note, took this up on appeal because it failed to address whether there was a required degree of connection between the exactions imposed by the city and the projected impact of the proposed development. So even though there may have been that connection, what the court was looking at here was whether there was the required degree of connection. So even if it was an essential nexus, was that essential nexus proportionate to the actual impact of the proposed development in the case? Again, just restating what we just addressed, whether the requirement has some reasonable relationship or nexus to the use to which the property is being made, or, and this is something that comes up often when we talk about exactions, is the land use authority merely being used as the application and the condition merely being used as an excuse for taking property simply because at that particular moment the landowner is asking for the city for some license or permit? Is this just an opportunistic, chance for the land use authority to take some property and couch it as an exaction? As we know, the court in Dolan found that neither of those conditions were reasonable. And I've attached a few quotes to highlight the importance of those findings and those holdings, but I think the bottom one is most important here. No precise mathematical calculation is required, but the city must make some effort to quantify its findings in support of the dedication for the pedestrian bicycle pathway beyond the conclusory statement that it could offset some of the traffic demand generated. And I think as we talk about exactions, as we talk about impact fees more specifically, we don't require absolute precision in mathematical calculation. This is brought up in a series of BAM cases that we'll talk about in just a minute. But there is an effort as we look at how impact fees are prepared, how they're calculated, how they're enacted, to quantify what those impacts are, and then identify a way to mitigate those impacts through the enactment and establishment of impact fees. I added a brief slide on, I mentioned the BAM series of cases. Those are Utah Supreme Court cases regarding an exaction of additional right-of-way for road construction. I won't go into the details too much, but I found this little quip to be kind of entertaining. The Utah Supreme Court in that case said any two numbers measured by the same units form a proportion. So to be roughly proportionate literally means to be roughly related, not necessarily roughly equivalent. And then the proportion of 1 to 1.01 is roughly equivalent, while the proportion of 1 to 3 is not. And so what the court in this BAM case is driving at is that rather than using the quote unquote rough proportionality analysis or terminology. They said rather than adopting the name chosen by the United States Supreme Court, we will use the more workable description of rough equivalence on the assumption that it represents what the Dolan Court actually meant. So love to see the the Utah Supreme Court tell the United States Supreme Court what they actually meant. It's always good to have those little quips in our case law. One more case I wanted to mention, and this one, in terms of impact fees, is probably the most significant United States Supreme Court case. Koontz v. St. Johns River Water Management District was a case where the landowner applied to the Water Management District, who had land use authority over his application. As a part of his application, he actually offered to dedicate a portion of his land in satisfaction of a statutory requirement to do so. But the district didn't accept his proposed dedication requirement and said he either needed to dedicate more, and they pretty much took most of his land, or they gave him the option of paying money that the district would use to improve additional district-owned land outside of his project. And this case made its way up to the United States Supreme Court, where the applicable holding, at least as it relates to impact fees, was that the rough proportionality analysis of Nolan-Dolan applies to the demand or the exaction for actual money. And again, that's significant as we talk about impact fees, which are, in essence, a payment of money to mitigate impacts. They're an exaction of money tied to a land use approval. So now I just want to talk briefly about what impact fees looked like in Utah prior to the adoption of the Impact Fee Act. I think it's helpful to understand kind of where we started and how we got to where we are today. And as you look through the relevant case law related to municipalities and local governments' imposition of, they weren't necessarily called impact fees, but development-related fees, it was pretty inharmonious, and it was really kind of scattered from jurisdiction to jurisdiction about how those were imposed, whether or not there was actual authority to do so. Oftentimes they were viewed as revenue generating measures and not actually fees that were collected in an attempt to mitigate impacts from future development. So we see a number of cases in Utah that challenge not only the authority of jurisdictions to collect those impact fees, but also the reasonableness with which those fees were collected. And it's those cases that lead to, I believe, the Utah State Legislature stepping in and saying, hey, we're going to codify what authority jurisdictions actually have to do this, and how they do that procedurally, and what that looks like for jurisdictions across the state. This little quip from the Banbury Court just highlights that they recognized when they issued their decision in 1981 that we're still trying to struggle to define what the limits of reasonableness are when it comes to exacting fees related to development. And it says, without legal limits imposed by statute or constitution, subdivision charges could easily be used to avoid statutory requirements for bonding municipal improvements, statutory limits on municipal taxation, and legal limits on restrictive or exclusionary zoning. So the court here recognized that, from jurisdiction to jurisdiction, we're all similarly agreed that we have some authority to do so, but what does that look like? How do we do that? And how do we make it more consistent across the state? I've listed here just a few of the early cases. The first one, Murray City, goes back all the way to 1964, and it's a sewer service charge that was based upon actual usage that was imposed to the school district. I won't go into the details of all these, but I simply list them here to highlight that, as far back as 1964, again, looking at this Utah or United States Supreme Court cases and the Impact Fees Act, which was adopted in 1994, courts struggled for decades trying to figure out the best way to impose development-related impact fees and the authority to do so. Again, I won't touch on each one of these briefly. You can go through those when you have some additional time. Encourage you to read them. I think they're pretty interesting reads. It's coming from an attorney, but I think they're relevant in the scope of, you know, how our municipalities authorized to collect those and use them. A lot of these early cases you'll find had principles that were pretty consistent throughout the years, but still struggled again to really hone in on the best way to do this broadly throughout the state. Two cases that I do want to mention, again, these are exaction related cases that kind of paved the way for the Utah Impact Fees Act. These are Utah Supreme Court cases, one of which, Call v. City of West Jordan, spanned over 13 years of litigation. It's interesting to look at the procedural history of that case and read some of those decisions. But it's truly kind of a trailblazer in terms of giving us kind of the framework that we needed in order to adopt the Impact Fees Act and set the stage for that. The second case, Banbury Development, briefly mentioned that case earlier when we talked about how the court here recognized that there was so much incongruity between jurisdictions in charging those, and that we needed to determine the reasonableness of those fees. Again, just want to dive quickly into Call v. City of West Jordan. This case, super long case. I mean, it spanned a number of years, and as was mentioned in a previous video on exactions, this case was actually mentioned in the Nolan United States Supreme Court case. The court there referenced this and identified that local jurisdictions are trying to resolve the same issues that were present in that case. This one the issue here rested on an ordinance that the city adopted requiring developers to dedicate a portion of their land in connection with the land use approval. The land that was donated was to be used for flood control or recreational facilities. Call challenged that on a number of different bases. One of those being that there was no recognizable benefit to his development. It was simply just a taking of land that he didn't receive any compensation or benefit from. The procedural history of these cases is pretty interesting. As you look through these, the first two cases were really challenges to the constitutionality of the ordinance. The Utah Supreme Court upheld the ordinance as constitutional on its face, but in Call 2, on a rehearing, they actually recognized that it may not have been applied in a constitutional manner as to Call. And so they directed the trial court to hear some additional evidence and find whether or not the city had over-collected from him, whether the fees that were collected were reasonable as to Call. Ultimately, Call wins. I won't go through all the procedural history, but ultimately he wins, and not on the substantive issue of whether or not the fee was reasonable, but actually on a procedural challenge that the ordinance wasn't adopted correctly. And as such, the court nullified the ordinance and he was awarded some fees. He kept going. He didn't give it up. He appealed a number of other claims and issues and tried to get attorney's fees, and the court, just, kind of sick of him, denied all those claims and sent him on his way with his impact fees returned or refunded to him. Again, the significance of this is that Call really just identified that there was a need at the time for some additional clarity and some uniformity on how to prepare, adopt, and implement impact fees. The Banbury case, also a super relevant case, established what we call the reasonableness factors of impact fees. For the sake of time, I'm just going to cruise through this a little bit more speedily so we can get to the meat of this presentation. But if you look at my additional materials, there's some commentary and some analysis on this Banbury case. But what the court identified here was that there needs to be an equitable sharing of the capital cost between past and future growth. And they came up with these 7 factors to help jurisdictions determine what equitable actually meant and what that looked like. I won't go through each of these, but these are crucial and pivotal in paving the way for the Impact Fees Act itself. And as we go through the Impact Fees Act, you'll actually see each one of these factors codified to some extent within the impact fees itself. Briefly, again, just to kind of close the door on Banbury here, the court draws the conclusion that in the context of monetary exactions, reasonableness is not measured in the traditional land use test of rational basis or reasonably debatable. And Justice Oaks actually says, rather, reasonableness obviously holds the municipality to a higher standard of rationality than the requirement that its actions not be arbitrary or capricious. So it helped clarify what the court had decided to call in the previous Utah and United States Supreme Court cases on this matter, but there was still some room to actually codify those principles in statute. So that brings us to the Impact Fees Act itself. This is hopefully where we have the bulk of our conversation. The act itself was introduced in 1994, and in terms of legislation, in my mind, it's more simple than other bills that we see quite often. It's organized pretty succinctly and establishes pretty clearly a lot of the principles that we just discussed in the United States Supreme Court and Utah cases on exactions and the collection of monies as a mitigation measure to future development activity. We'll go through each one of these sections briefly as part of our discussion here, but a more detailed analysis is also included in the impact fee materials associated with this presentation. So an impact fee defined, again, it's an exaction, but more specifically, it's a payment of money associated with a development activity, which development activity is a defined term we're going to talk about in just a second. And it's imposed as a condition of development approval, again, to mitigate the impacts of that development on existing and future public infrastructure. It's not a tax. It's not a special assessment. There's a number of previous cases that are included in the materials that talk about challenges to impact fees as just that, as revenue generating measures, as hookup fees, as other fees that aren't quote unquote an impact fee. A lot of those challenges fail, but what we do know today, based upon the Impact Fee Act itself, is that it's not any of those other measures. In fact, as we'll see later, impact fees can't be used to collect more than the government's share of the cost of public facilities, nor can they be used to make up existing deficiencies. So in that sense, they aren't any of these other things. They are specifically to mitigate the impact of new development on public infrastructure. A brief introduction to a few of the useful definitions. You should refer to the Impact Fees Act itself for all of those definitions and the specific language of those definitions, but a few that are helpful, I think, for our conversation here. First being the development activity. So this describes what type of development activity, what type of construction, what type of building is actually subject to the imposition of an impact fee. And briefly, it's defined as any construction or expansion of a building, structure, or use, any change in use of a building or structure, or any changes in the use of that land, and this is the important part, that creates additional demand and need for public facilities. So summarized, anything that increases the demand for public facilities could be categorized as development activity under the Impact Fees Act. The enactment is simply the formalization of the impact fee itself. If you're a city or a county or a town or any municipality, it's synonymous with an ordinance. So when you adopt an impact fee, you do it by an enactment, but it's approved as an ordinance. For districts and special service districts, that technically usually takes the form of resolution or board resolution. Same with private entities who are also approved to enact impact fees. The impact fee analysis and the impact fee facilities plan are two required components. In most cases, I should say required. The impact fee analysis simply analyzes what the impacts are from proposed development activities and determines what public improvements need to be made. The impact fee facilities plan, or the IFFP, identifies what specific facilities are needed and the timing of those and when they're to be constructed in order to maintain an existing level of service. And perhaps more importantly, and one of the biggest key things that cities, one of the biggest key things that cities and developers alike look at is the financing mechanisms, right? How is all of that public infrastructure to be financed in addition to the collection of impact fees? The local political subdivision just defines who can collect impact fees. Again, that includes counties, municipalities, so cities and towns, local districts, special service districts, and then the point of the mountain state land authority. The project improvements are improvements that are generally project related. They're distinguished from system improvements, which we'll talk about in just a minute, in that project improvements are not funded through the collection of impact fees. These are smaller scale project or subdivision specific improvements that, even though they may be public, don't serve the larger community and are therefore not included in the IFA and the IFFP. Public facilities, this is an important one. This defines what local jurisdictions can collect impact fees for. Briefly, we'll talk about them here. Just there's water rights, wastewater, stormwater, municipal power facilities, roadway facilities, parks, trails, and open space, public safety facilities with some specific limitations about what that looks like, including, the payment of apparatus over $500,000, environmental mitigation, and municipal natural gas facilities. In my limited experience, I haven't seen an environmental mitigation impact fee. It'd be interesting to know if anyone has seen that or knows of one, if you could maybe list it in the comments, but it's specifically called out. There's some additional language in the act talking about how to impose and manage the environmental mitigation impact fees. Roadway facilities, this is a huge one. Every jurisdiction that manages roadways or owns public rights of way is always worried about how they're going to finance those and construct those, and more specifically, what's included therein. The Impact Fees Act allows for roadway facilities to include what it references as necessary appurtenances, and that can include, sidewalk, streetlights, landscaping in the park strip, and other, again, appurtenances that are necessary. It's important to note that any of those need to be included in the impact fee facilities plan to identify, again, what that level of service actually is, so that you're not under collecting or over collecting impact fees for improvements that may or may not be considered in that analysis and facilities plan. A service area defines generally the area where the impact fees will be collected, and system improvements, as I mentioned earlier, are those items that are designed to provide service to the larger neighborhood, to the larger community, and are those items of public facilities for which impact fees are collected. Again, briefly, we talked about it earlier. Who may impose impact fees? Well, counties, municipalities, local districts, special service districts, point of the Mountain State Land Authority. Also, certain private entities who generally provide public facilities may impose that. This presentation doesn't dive into that, but the materials that are associated here with do include some discussion on that. What can impact fees be collected for? Well, we talked about it earlier, those public facilities, there's 9 of them. Each city or each county, each municipality that's listening today should consider what facilities they need to provide. There are some cities in Utah that do still have municipal power services. They can collect an impact fee for that. Other cities don't. They rely on Rocky Mountain or other power suppliers. They don't collect an impact fee for those. So each jurisdiction that intends to impose an impact fee needs to determine for themselves what those public facilities are going to be. There are some limitations built into the Impact Fees Act about who is exempt from paying impact fees, or the reasons why impact fees may be collected. As I mentioned earlier, no impact fees can be collected to cure existing deficiencies. As you read through an impact fee analysis and an impact fee facilities plan, you'll often find an analysis in the calculation of impact fees that shows what percent of future costs will be attributable to new growth. And this is important because it identifies that some of that cost may be tied to the curing of existing deficiencies. And as such, new development is not required. And legally, a local jurisdiction cannot require an impact fee to cure that existing deficiency. Additionally, impact fees may not be imposed to raise the established level of service. There is an exception to this built into the Act. Generally, it says that you may raise the established level of service if you're introducing a new public facility that the city hasn't previously collected an impact fee for, or in other instances, if the established level of service is being raised and it can be maintained within a period of 6 years. Again, more detail on that in the associated materials. And finally, this one's important. The local jurisdiction can't use impact fees as a revenue generating measure. In other words, they specifically can't recoup more than their cost for the public facilities that are planned within the IFFP. The Act also identifies what parties may be exempt from paying impact fees. I won't go through each one of these. I'll just make a few honorable mentions here. The one that comes up the most and that jurisdictions that I've represented often have the hardest time with is working with school districts. It's not a job at school districts, but simply to say that there's been a number of cases and a lot of confusion about the scope of school districts' impacts on public facilities. The Impact Fees Act goes into a lot more detail about that. The materials provided with this presentation also identify some of the more specific details and exceptions regarding the imposition of impact fees on school districts. One of the things that is clear, however, that I'll just briefly mention is that there is no imposition of any parks, trails, or open space impact fees on a school district. I think we might all agree, there might be some that don't, that right, those facilities, a school district provides its own essentially open space facilities, and therefore there is no impact. And as you look at the Nolan and Dolan analysis, I think you can make a pretty good argument that schools do their own mitigation in terms of those impacts. Again, for the sake of time, I'll skip over some of this. Again, there's more detail on the limitations and the scope of collecting impact fees from schools. Briefly stated, if there is an identified impact from the construction or development activity of a school, a local jurisdiction has authority to collect certain impact fees from that school. The Impact Fees Act does make clear that if at the time of the enactment of a new or amended impact fee, it's known where a school is going to be, the enactment should consider, and the impact fee facilities plan should include some data about what that impact is going to be and account for that specific impact. This is a hot topic. Maybe we'll spend just a few minutes on. Came up recently as well in the Land Use Institute's recent fall conference about the exception of internal ADUs from paying impact fees. This is a recent change to state law, as recent as 2021, where internal ADUs are now a permitted use, generally are a permitted use in areas zoned residential. With that, they also made a change to the Utah Impact Fees Act, stating that no impact fees could be collected against internal ADUs. A lot of politics and debate that we could get into on this one. I think there's some justifications there on both sides, but it's worth mentioning that, while it's not specifically addressed in the Impact Fees Act, I think this prohibition against collecting an impact fee against internal ADUs applies to internal ADUs that are included as new construction, with which we see a lot of these days with the current housing market the way it is, but also to new construction of an ADU within an existing dwelling. One other note I wanted to make on the impact fees and ADUs is the imposition of impact fees against external ADUs. The Impact Fees Act is actually silent on the imposition of impact fees against an external ADU. And just so we're all on the same page, an external ADU is one that's not attached to the primary building itself. So it's arguable and beyond the scope of this presentation itself of whether or not a local government may actually impose impact fees for that specific use. I think it is worth mentioning, and it's probably a best practice for those that are responsible for enacting impact fees within a local jurisdiction, that if you're going to make that part of your impact fee analysis for the public facilities that you manage, you should include that specific data and measure the specific impacts of those external ADUs on public facilities within your city. A word of caution, this also came up recently in the Land Use Institute's fall conference, is that that's a slippery slope. You can cut both ways when you're making those, initial data backed assumptions about what impact fees really are. I'm not an expert in any of this by any means, but I've seen situations where, as has been mentioned in other areas of exaction law, where a multifamily home may have a greater impact on public facilities than a single family home that's 3 or 4 times the size, right? And so it's interesting, and would be, it'd be quite interesting to look at what the impacts actually were between external ADUs, their primary structure, and even a primary structure without any ADU of similar combined size. Now we get briefly to the establishment. How do we do that? Well, before you impose an impact fee and actually collect a fee from development, you have to study and prepare an IFFP. The IFFP need not be prepared if your jurisdiction actually has those components of the IFFP in its general plan. Additionally, if you're a smaller jurisdiction and you serve a population of less than 5,000 people, or you don't charge more than $250,000 annually, you're not required to prepare an IFFP. However, you do, prior to collecting impact fees, have to notify the public according to the notice requirements of the Impact Fees Act of your intention to collect those impact fees. And we'll talk about that again in just a moment. Here's some of the components of an IFFP. Again, I don't have time to go through all of them, but it identifies the existing level of surface, which is of critical importance when you're talking about how do you mitigate future impacts while maintaining that level of service. It identifies excess capacity and looks at the revenue sources to pay for those future improvements to maintain that level of service while mitigating future development impacts. The impact fee analysis also includes a number of things that are required to be included within that analysis. One of the more important things that I've mentioned earlier is that it identifies how the impact fee was calculated. So it spells all of that out and details it in a way that's simple and easy to understand, hopefully, if it's doing it correctly, and allows an individual who's subject to paying those impact fees to determine whether it's properly prepared, assessed, and collected from them. As mentioned previously, the enactment is itself an ordinance. It's the documents, the formalization of the impact fee facilities plan and the impact fee analysis codified or rather adopted by ordinance for a jurisdiction that imposes an impact fee. Once an impact fee enactment has been accepted and approved by the local jurisdiction, it doesn't take effect for 90 days. Oftentimes you'll see in jurisdictions where an impact fee is raised, a rush on building permits, right? Or a rush on the bank, essentially, to say, hey, we're going to get this in as quick as we can, especially if you see a huge increase in impact fees. The reverse, however, I've seen in my practice as well, where if an impact fee is lowered, oftentimes out of, the goodness of their heart, a jurisdiction will say, our current impact fee is higher than the one that we've just adopted. We're going to reduce the current impact fee to the amount of the newly adopted impact fee until the effective date. Here are a number of things that must be included within the enactment. I won't go through them again just for the sake of time, but it's pretty clear, and the act makes it pretty clear to understand what needs to be included within an impact fee enactment. The materials include a sample impact fee enactment that you can refer to as you're preparing the enactment to be approved. There are also a number of fees that can be, these are optional items to be included within the enactment. Also, those are mentioned within the sample impact fee enactment provided. As we recognized in the call case earlier, he won on a technical, I wouldn't call it a technicality, on a procedural default in the city's adoption of that ordinance. And as a result, the Utah State Legislature actually adopted pretty clear notice requirements for impact fees. These are broken down really into 4 sections, and I've got them itemized here. The first is the notice of intent to prepare an impact fee facilities plan. So this is just a notification that a local jurisdiction intends to contract or prepare their own impact fee facilities plan. They're required to do that 10 days and follow some additional notice procedures before they do that. The second is the notice of intent to adopt or amend an impact fee facilities plan. And this is just after the impact fee facilities plan has been prepared, the jurisdiction would notice up a public hearing, make the copy of the IFFP available, as well as a copy to be understood by a lay person, as the statute reads. And then the third would be a notice of intent to prepare an impact fee analysis. This can be done simultaneously. Oftentimes you'll see it done simultaneously as consultants help and assist jurisdictions with preparing an IFFP or an IFA. But it also has certain notice requirements. It's not required to have a public hearing. Oftentimes you'll simply see that as an attachment to an enactment. There's a sample ordinance in the materials that kind of demonstrates how a jurisdiction can incorporate that into their enactment process. And then finally, the notice of intent to adopt an impact fee enactment. This again is just your ordinance. This is treated similarly to a land use decision. So there's a public hearing requirement, notice requirements. I will mention, and I'm going to skip through a few of these slides again just for the sake of time, but I will mention that these notice requirements, and if there's any city recorders or secretaries or treasurers that have to facilitate the notice requirements, they're constantly changing. They've changed recently in the last legislative session. And so my best advice to you would simply be to work with your local legal counsel or individual who helps and assists with the notice requirements to make sure that you're compliant with those. Again, as we saw in the call case, that's one of the grounds for which an impact fee can be challenged. And it's important that they be strictly followed and adhered to in terms of enacting an impact fee. Once impact fees have been enacted, they can start being collected again 90 days after the enactment has gone into place. There's strict accounting requirements for impact fees. Any impact fee that gets paid has to have a receipt that shows the source and the amount of the impact fee, as well as the date it was paid, the project it was collected from, and the name and address of the individual paying the fees. This is important for 2 reasons. One, there's a report that has to be sent to the state every year accounting for these impact fees. But also, if there's ever a challenge to these impact fees, these details are required to be included and may be relevant in terms of a refund that may be due as part of that challenge. Another important detail of impact fees is once they're collected, they have to be spent or encumbered. There's no real clear definition of what encumbered means. I think in practice, most attorneys would tell you that encumbered means it's contracted to be spent. So it's not available. It's been committed to some form of public facility for which that impact fee was collected. That has to occur within 6 years after the date of collection. And there's some relevant Utah Supreme Court case on a challenge to the authorized spending of collected impact fees after that 6-year period. And then again, there may be situations where an impact fee isn't spent within the 6 years, or a challenge is successful and it needs to be refunded. The Impact Fees Act talks about specifically what those refunds look like. Who can bring a challenge? Anybody who lives within a service area. That's my easiest answer, again, for the sake of time. And then there's 4 particular types of challenges that are identified in the Impact Fee Act. There's a notice challenge, simply stating that the city didn't follow strict notice requirements when they notified their intent to prepare or adopt an IFFP or an enactment. There's a procedural challenge, meaning that there's some defect in the procedures followed by the city. I failed to mention that the notice challenge can only be brought 30 days after an impact fee is paid. A procedural challenge can be brought 180 days after a payment is made. And then the third type of challenge is an impact fee challenge to the impact fee itself. That might be on the data included in the IFFP, some of the assumptions made, the calculation. That can be brought 1 year after payment of an impact fee. And then fourth, the impermissible or untimely expenditure. So this is what we talked about earlier. If the impact fee is not spent on a public facility that was identified in an IFFP, or if the city failed to spend that within the 6-year period, an individual who's authorized to bring a challenge can do so within 1 year if it's an impermissible expenditure, or 2 years after the 6-year period if the city has failed to spend that money. There's administrative and judicial procedures set forth within the Impact Fees Act regarding a challenge. I won't go through those again for the sake of time. Hopefully you never have to face a challenge, and hopefully as a developer or payer of impact fees, you won't ever have to levy a challenge. But if you do, there's specific procedures within the Act for addressing that. And then there's just a few honorable mentions of some relevant cases, again, before and after the Impact Fees Act were adopted. It's interesting to read through those and look at the kind of the juxtaposition of how the analysis was done and the statutory authority that's applied to the review of those cases after the Impact Fees Act. It's significantly helped clarify and clean up how jurisdictions impose and collect impact fees and use those, and helpful to read through those. So sorry for rushing through that at the end, but again, sorry, I'm going to stop sharing my screen here. Something I'm passionate about. It's great to have an understanding of how that works and how the impact fees are properly used. As was mentioned in a previous video on exactions, I think we'll continue to see challenges to how how impact fees are collected, and see some new case law on that. But that's the process of making this a more clean and more roughly proportionate exaction of monies related to development. So happy to answer any questions, and if there are none, then thank you for giving me the opportunity to share some thoughts with you on impact fees.
Thank you, Chase. We appreciate your preparation, and particularly the extended materials that are available online. We'll also post the PowerPoint, so you'll have those details. And I might also refer those interested in just generally the concept of local fees to a session that's recorded and available for streaming online from our Utah Land Use Institute Fall Conference 2023. The session's entitled Transportation and Other Fees, but it also covers many of the topics peculiar to impact, to things that are not impact fees. So please feel free to enjoy those as well. Again, thank you, Chase. Appreciate it. We will now have time to talk a little bit about vested rights. In this little segue that will not be part of the online recording, let me mention to those observing that we are going to go beyond 12 o'clock, mainly to make sure we give Kyle the chance to cover his topic.